Hey there, welcome back to yet another episode in the journey of demystifying the Patent Act, where we understand and interpret the Patent Act in simple manner for finding solutions for any situations that we encounter with respect to our ideas, inventions, and patents. Remember, in our last episode, we discussed about the forms and timelines required to initiate a filing. We spoke of Form 2 that is required to provide details about our invention, either through provisional specification or complete specification. In this session, we will discuss about the requirements of provisional specification. In what scenarios do we need to use provisional specification, and why do we file provisional specification? Consider a scenario where you have been working on an invention, you have put in months on it, you have put in efforts on it to come up with the first version of your invention. You still think that you are far away or few months away from the final version of your invention where all the components, all the features will be in place. While you work towards the final version of your invention with your expectations and with the requirements in mind, there is a possibility that another person working on a similar invention could go ahead and file an application. Now in India, first to file is considered as first to invent. This could cause problems to you on multiple levels. First and foremost, if you were to file an application in next few months, this particular application which was filed by another person would be treated as a prior art against you, would pose hurdle towards your patentability. Second, if the person were to get a grant on his patent application, then it could cause trouble to you when you go to market with your product. So first, you lost a chance to get a patent. Second, you got a problem at the market end also, where you can't practice your invention because somebody already has a patent over it. So what do we need to do to avoid such situations? Patent Act provides an option for you to file a provisional application, which is not as detailed as your complete specification, but it is also not a rough draft. Provisional application can be drafted to provide basic details of your invention about how it works and what all features and components we are talking about, and can be filed at the patent office to claim a filing date. It's more like a placeholder for your complete specification, which should be filed in next few months. This way, you can keep working on your invention without worrying that somebody else might beat you in the filing race, because that could have problem for your filing, later filing, as well as on your market launch. So Section 9 gives us multiple use cases to understand how do we need to utilize the provision given to us. If you were to file an application, provisional application, you need to convert this provisional application in a regular application within 12 months. Now, failing to do so will result in abandonment of your invention. In the sense, you will not have any invention as such. Your filing date will go away, your invention will go away. So you need to file a regular application within 12 months from the filing date of the provisional application, 9.1. Now, if you can file one provisional application, you can file multiple provisional applications also. You can have changes, you can have improvements, you can have modifications. In that case, what happens? 9.2 talks about that case as well, where you have first provisional application, then you filed another provisional application, and then you converted that into a regular application. Now here, even though there are multiple provisional applications, the filing date will be considered this, and 12 months will be considered from the first filing date. While we talk about the regular application in light of provisional applications, one thing needs to be kept in mind, that the regular application has to be fairly based on the provisional application to claim this date. If it contains any information which is not disclosed substantially in one of these, then the date of that content will be the date of filing date of this regular application. Understood? If it is disclosed in one of these applications, P1 and P2, your regular application will claim date from P1 or P2. If it is not disclosed in there, then the date will be the filing date of the regular application, of that portion, not the entire thing. There could be a scenario where you filed a regular application and you realized that the claims were not drafted in compliance with the act, or you forgot to describe in detail few critical information about your invention. What do? You can request the controller to consider that regular application that you had filed as provisional application, and then later on file regular application as if this was your first provisional application. I'll show you. Section 9.3. So this was a regular application to start with. Within 12 months, you requested the controller that this application should be treated as a provisional application. And then I will replace that provisional application with another regular application. All this has to be done within 12 months. So that concept remains the same, 12 months. From the provisional application to the regular application, you need to complete the filing in 12 months. You can have P1 says provisional to regular, 9.1. 9.2 says if you have two provisional applications, you can convert them into a regular application, provided both the provisional applications are cognate or modification to each other connected to an invention within 12 months from P1. Third one, I had a regular application. I can convert that into a provisional application and then later convert it to another regular application. Everything within 12 months. Nothing should happen after 12 months. Now, there is another case where you want to, let's see the case first. Where you have filed a provisional application, you convert it into a regular application as per 9.1, 12 months. Or there could be another application, converted into, within 12 months, you convert it into a regular application. Or as per 9.3, you had a regular application, you requested the controller to convert that into a provisional application, again within 12 months, and later on converted that into a regular application. All that is allowed. We are just doing 9.1 and 9.3 here. So 9.4 says that at any point, any time before grant of the patent, you can request the controller to cancel the provisional applications. So we are cancelling this provisional application. What does it mean? It means that we are post-dating our application. We are post-dating our application to the date when we file the regular application. Now, under what scenario would you do it? See, you may be confident that nothing has happened between your provisional date and regular date. In this 12-month, no new prior art came. You are confident that no publication was done, no usage was done. So your invention is still an invention. There is no prior art for it. So you may think that why not I post-date the application by 12 months? Because the benefit of this will be so basically, let's say 2020 was provisional date, 2021 you filed, Jan 21. So let's say for 20 years will start from here. So 2040 is where your term will end. But if you were to do this post-dating, you were to cancel this provisional, then your date will start from here. You will get another year of protection, provided there is no prior art that has come here which could cause problem to your patentability. Interesting concept. So with this, we know that you can file provisional applications when you are not ready with the inventions. You can file multiple provisional applications also. You can convert a regular application into a provisional and then convert it again in provisional, all in 12 months. And you can cancel the provisional application also. I hope this gave you some clarity with respect to when to file a provisional application, and if you have filed a provisional application, within how much time you need to convert that into a regular application for your date to be satisfied. 12 months from the initial filing date. January 2020, then it has to be within January 2021. March 2020, it has to be March 2021. Like that, you need to calculate your 12 months, within 12 months. In the next episode, we will understand the requirements of Form 2 for complete specification. What details do we need to provide? In how much detail do we need to provide the invention? And what all sections should be there for an application to be in the prescribed format as provided by the Patent Office or the Patent Act. Till then, have a good day and take care. Bye-bye.